In this presentation, we will discuss employment law. At the end of this, we will be able to describe the concept of employment at will, list and explain the wrongful discharge, describe laws for employee working conditions, list and explain laws related to worker benefits, describe civil rights legislation as it relates to employment, and explain the Age Discrimination in Employment Act. An employment agreement is going to be an agreement between an employee and an employer. This agreement can be set up in a formal way with a complex written document, or it could be an oral agreement between an employer and an employee. The principal idea and concept within the employment process is the idea of employment at will. Employment at will basically means that both the employer and the employee have engaged in this employment of their free will and then can terminate the employment at any time, pretty much given any circumstance under the general rules under normal cases. And that means that either the employee and the employer have the opportunity at any time to stop employment and pursue other opportunities, which typically in general is a good thing. That's going to be the principal foundation idea of employment, that both individuals can terminate the employment process at any time and pursue other options. However, there are situations where it's seen that the employer in particular may be able to abuse this process because the employer often has more control or power within a situation of an employee or an employee type of situation. It could be seen that the employer then may be able to abuse this ability to just terminate employment just at any given time for no reason, not even having to give any cause for the termination of employment. Because of this, we have the foundational principle of employment at free will, and then the law is going to create some exceptions to the rule, some exceptions particularly to the employer side of things, where we have to have some additional steps in order to terminate rather than being able to terminate without even giving any cause for it. These exceptions come into a few different categories. We can have contractual exceptions, we can have statutory exceptions, and we have created wrongful discharge exceptions. Contractual exceptions mean that there's going to be some type of contractual exception in the agreement, in the contract between the employee and the employer at the time of employment. So when we create the contract, then we can add these exceptions within to the contract agreement so that the default setting is not just employment at will, but also taking into consideration whatever details are put in as a negotiation between the employer and the employee. This is an ideal situation, but it only really works well when both the employer and the employee have pretty equal standings within a negotiation process. In other words, when we're talking about employees that are highly valuable employees, highly skilled employees, they often have a lot more bargaining ability within a negotiation process, and they can negotiate a good and fair employment contract. When we're talking about employees that don't have a lot of skills, then they're often more kind of at the will of the employer, and there could need to be then other protections possibly than just the ability to have that negotiation because of the difference in need between the individuals. We could have a collective bargaining agreement, which is basically the case where a union often would represent the employees as a group of employees, and they could have such agreements within the bargaining agreement to prevent the employer from terminating an employee without just cause. For example, the National Labor Relations Act, the NLRA, prevent unfair discharge of employees. So the employer, in other words, would have to basically list some type of some reason for the discharge of an employee. Collective bargaining agreements often also going to have some type of grievance procedure, meaning if an employee was terminated for some type of process, they can go through some type of appeal process to, if they think that the termination was unfair or done on unjust grounds, we can go through a grievance process and review the grounds for termination. The grievance process basically being like an appeal process that would say that there was no just cause for the termination. There are also statutory exceptions to the at-will clause. So the at-will clause, remember, is going to be the default, meaning that an employer-employee relationship, either party can terminate at any given time. that being the default, with no just cause as the default, except for some of these exceptions. If we have a statutory exception, that means the federal government has passed some law, some legislation to add a level of protection, typically to the employee, to guard against an at-will type doctrine, in which case the employer would have some more restrictions in terms of being able to fire certain individuals. And so some of those are typically going to focus in on legislation that's going to be related to discrimination-based legislation, color, creed, national origin, or gender. They then passed legislation that has to do with age, disability, and service in the armed forces. And finally, we have some focus in the legislation that has to do with hardship that results from a firm deciding to move the business. So these are going to be the main focuses within these types of statutory exceptions to the law. Civil rights laws are also going to be a component in terms of being a check against the general default rule, that there's employment at will and we can terminate anybody at any time, or the employer can terminate and the employee can terminate at any given time. Remember, that is the default. We have some civil rights laws that are also going to be in place, and of course the laws are in general there to protect employees and certain types of employees in certain situations. And so the civil rights law is going to have some restrictions in this case as well, in order to restrict the employer from terminating legislation or terminating an employee in certain situations. And some of this has to do with the Equal Pay Act, parts of the Civil Rights Act, Age Discrimination and Employment Act, the Uniformed Services Employment and Reemployment Rights Act, and the Americans with Disabilities Act. So these are going to be some of cases which we could apply to and fall under civil rights law that would be an exception to the general rule of the at-will law, which could be restricting the employer from terminating without any cause. The term wrongful discharge would mean that the employer has in some way violated some of these laws or regulations or the contract in discharging an employee, and in so doing, the employee then would have grounds for a lawsuit against the employer on the grounds of the wrongful discharge. The idea being that the employer discharged the employee unfairly for one of these reasons. An employee could make a case for wrongful discharge using promissory estoppel. Promissory estoppel is a case where, although we had an agreement, remember the default agreement is an at-will agreement, and the employer then would typically, at the default, have the ability to discharge the employee. However, if the employee had in some form or fashion a promise made to them, given some more higher security for their employment situation by either the employer directly or by an agent of the company, and then the employee believed that and acted on that, made decisions based on that promise, and then was terminated in violation of this promise that was given, that would be a promissory estoppel. So the employer would have to make some type of promise, or an agent of the employee. The employee would then have to be able to agree or believe that promise and basically take actions and plan on that promise. And then, of course, the employer would have to violate the promise in termination, and that in some way would injure the employee, and that would be grounds for a wrongful discharge type case for promissory estoppel. A similar case could be made in many states, which would go against or go towards the wrongful discharge case, which would be related to fraud-related employment cases. And this is similar in that the concept here of fraud would be that there's some type of deception within the employment contract. And typically we could, that exception may be that the employer and the employee got into an employment contract, and the assumption by the employee was that there is potential, at least, for a long-term employment process within this position, whereas the employer knew from the get-go that it might be a short-term process and did not communicate that within the employment agreement. That's one type of thing where we could say, well, there's deception within the contract agreement, where one side felt that this had the potential, at least, to be a long-term negotiation, and the other did not make aware the short nature of the process and possibly that would be grounds for actual fraud within the negotiation, especially if it was expressed explicitly that there might be long-term potential when clearly there was not. Another type of argument that can be made for wrongful employment can be made under implied covenant, meaning that because the employer and employee are acting under an agreement in accordance to what would seem to be some type of covenant or agreement, then you would think that there would be a reason or a need for fairness and honesty within that agreement. And therefore, when there is going to be some type of termination, you would think that there has to be some fair and honest process or fair and honest reason for a type of termination, given the fact that it looks like there is an implied contract of continued employment, given the nature of employment, the continuation of employment in the day-to-day activities with the job. Now, many have argued here that if we accept this kind of interpretation of the employment contract, then that really isn't just an exception to the at-will agreement, which is basically saying that either party can terminate the agreement at any given time. The implied covenant tends to make you think, well, that means that you cannot terminate anyone at any given time. There is no real exception to that, because if there is an implied covenant and we have a duty of care and fairness to the employees given the employment agreement, then that would mandate that we would need to give some kind of reason for termination. In other words, if we're acting as if we have an ongoing agreement by having a daily transactions and acting as an employer and employee and acting as though that relationship will continue into the future, then if we suddenly terminate that agreement, then we would need to have some kind of just cause or reason for that termination. And to be fair and honest, we would have to provide that to the employee if we have that duty of care. So this kind of implied covenant may be stronger depending on the region of the country we're in, the states that we're in, and it's basically going to say that we have this duty of care just within the employment contract of itself. Up till now, we've talked about wrongful discharge and the company actually terminating an employment and the conditions in which that termination could be determined to be wrongful. There also could be cases where we have constructive discharge. And in these cases, you can imagine a situation where an employer may feel that they want to terminate an employee for whatever reason, possibly the reason not being one that would be a legal reason, and therefore, instead of terminating the employee, make the employee's work life not ideal. In other words, a constructive discharge would be taking actions that would make the employee's current employment process less than good, a bad work environment, meaning they could deny raises to the employee. They could give subpar recordings of the performance of the employee that aren't just, or they could just treat the employee at a lower level than their skill level. They could we could demote the employee and do these types of things just that would reduce the ability for the employee to work, possibly with the intention of the employee then quitting at some point in time. And that would be the concept of a constructive discharge. And we can see how, when we look at these contract laws and the employee agreements, how if there's a fear of a wrongful discharge in terms of termination, in some cases, unfortunately, this type of conduct could happen, in which case the employer takes other types of actions in order to force a type of termination, and that would be the case of constructive discharge. In addition to laws that regulate the wrongful termination of employees, we also have laws that regulate the conditions of employees, those working conditions, health and safety type laws. Occupational Safety and Health Administration, or OSHA, is a law that has the ability to regulate the labor conditions and standards for employees. That's going to be a tremendous type of power and authority that OSHA has in this realm in order to put some restrictions in terms of the types of procedures that would be involved for regulatory procedures. However, in order for a procedure to be put in place, or for OSHA's regulations or laws to be put in place, they must show that the new OSHA standards and regulations reasonably reduce the frequency and severity of employee injuries and illness. If they do, then OSHA can establish and enforce occupational health and safety standards, which employees must then comply with. The Fair Labor Standards Act has to do with the number of hours employees would be required to work, typically being 40. Has to do with age limits for children working, typically being 14, so prohibits employment of children under the age of 14, and has to do with the minimum wage, and typically individuals or employees that are in interstate commerce need to be paid the minimum wage, or higher, of course. If we look at the Fair Labor Standards Act, we're talking about a law that is going to be on the federal level. So note that the state level could put different types of laws that would have to basically have this floor. This would be the floor level, meaning, in other words, with regard to the minimum wage, the state may have minimum wages that are higher given the state minimum wage than a federal minimum wage. And the restrictions on the 40 hours per week may be a restriction for the federal, that the state may put more restrictions, including limiting the hours per day, possibly, so we don't have employees working tremendous 24-hour shifts in a day or something like that, or 16-hour shifts in multiple days, possibly, that being limited by state. And so we could have added restrictions from the state. Note also that the Fair Labor Standards Act, because it's a federal law, has some restrictions oftentimes in the application due to the fact that the federal law is really applicable when there's interstate commerce, meaning we're talking about businesses that do business over state lines. That's when the federal law is more applicable and where there's more jurisdiction for that federal law to take place. So there's going to be some restrictions in terms of when this minimum wage requirement would be put in place, as well as the other rules related to the Fair Labor and Standards Act. Many states, however, will have acts that will be similar, follow a similar pattern, have this at least as the minimum, and possibly have a higher threshold for benefits for workers typically. The Immigration Reform Act of 1986 is an act that's going to put more pressure on the employer to regulate the individuals that are working for them. For example, the employers are required to request and examine any documentation that will help for the identity and employment eligibility for all new hires, including U.S. citizens, permanent residents, and non-immigrant visa holders. And the idea here is to put more pressure on the employee to deal with the type of immigration problems, so that the employer then is responsible for double checking that the people that they are putting in place for work are people that are eligible to work in the country. The Federal Insurance Contribution Act, or FICA Act, is a social safety net program, one of the primary social safety net programs, which includes Social Security within the safety net program. The FICA Act and the Social Security then are going to collect payroll taxes from both the employer and the employee during the term of employment and pay that into the Social Security to the federal government. And the principal purpose of that is then to have that money paid back at the termination of employment, at usually the elder years of a person's life, in order to safeguard against that time period in which the employee or the worker is not currently working and earning more wages. Social Security and FICA taxes are mandatory, so this is another area where the employer really is by law given the responsibility, and that's commonly the case because, of course, the business is the one that has more to lose. They're easier to regulate because the business is a set place. So the business then is being put in charge in terms of setting in place and regulating the application of this law. In other words, the business owner can't just give out the $100 if they agree with an employee to pay $100 at the end of the week. They can't just give out the $100 and then expect the employee to pay things like the Federal Insurance Contribution Act or the FICA taxes. The employer, must take from the employee's $100 the employee's required payment or portion of the payment for the FICA taxes out, and then give the employee the net of it, not because the employer gets to keep it, but because they are responsible for then giving that money to the government for the employee. And on top of that, the employer is going to have to pay their portion of the Federal Insurance Contribution Act, the FICA taxes, based on the employee wages. The amount taken out of the employee check and the amount given by the employer or having to be contributed by the employee per employee will be in relation to the amount of wages earned by the employee. So it's going to be more of a flat type tax. So if there's whatever earnings go up, there's going to be a flat tax as the earnings increase, as people earn more. Typically, the FICA tax will go up to a cap. The benefits then will be paid out based on some type of calculation, typically based on income levels and how much was paid in, therefore, to the system to determine what the benefits will be paid out at the elderly age at the time of retirement. The Federal Unemployment Tax Act and the unemployment insurance systems of the state are there to help individuals who have lost employment through no fault of their own. So they're going to be helping individuals who, through no fault of their own, have lost employment, and therefore the employment insurance will be in place to provide the insurance needed or the money needed for hopefully that temporary amount of time where we get new employment through that process. Now, typically the federal unemployment FUTA will be given from the employer, meaning as we have the employees in place, the tax would be based on the employee's wages, but not taken out of the employee's check, paid by, rather, the employer on behalf of the employee. States' unemployment systems often work in the same way, where the employer would pay a portion and may have some differences from state to state, may require in some states part of it to be pulled from the wages of the employee. So the idea then, similar system, as part of the payroll taxes, paying for the Federal Unemployment Tax Act, FUTA, and any state SUTA type of taxes that would be paid as part of the payroll process in order to support those individuals who lose employment through no fault of their own. Workers' compensation has to do with workers and their families receiving benefits for losing their ability to work due to things like injuries or diseases or death that occurred on the job as a result of that job. So if a condition of the job resulted in some type of injury, disease, or death that reduced the ability to work or injured the individuals involved in some way, typically in a way that would not allow them to continue work, then they would be subject to benefits possibly through workers' compensation. There are also laws that have to do with retirement plans and retirement contemplation, including pension plan regulation plans, including the Employee Retirement Income Security Act, ERISA. And this has to do with, we know that a major benefit for most employees that they can give, if choosing to do so, to the employee is a retirement plan of some kind. We need to be really careful, however, with the retirement plan and make sure that we're applying it in accordance with regulations, because, of course, that retirement plan or the pension plan is going to be something that the employees are dependent on in the future. Because of that, there's more regulations within the pension plan. Typically, for example, the money going into the pension plan would generally need to be in a separate trust which is separate from the normal operations of the business. And in that way, there's going to be more ability or more likelihood that we know the trust is going to be there in the case of retirement, or we can calculate what's in the trust in separate from what the company has. We also want to make sure that there's some formal policy in terms of who qualifies for the retirement plans for the business, and have regulations in terms of that retirement procedures, as well as who has rights to the benefits that they have earned through employment. Again, this is something that's very important because employees may earn pension plan benefits during the time of employment, whereas they may not be employed at the time of retirement and still be due and eligible for those payments at that point. And we want to make sure that they're receiving the benefits that they earned during the time of employment. They didn't get those benefits at the time they were working because they were promised them in the future, but those benefits they are getting in the future are a result of the work they did at the point in time they were there. So those are going to be regulations for regulating pension plans and retirement plans for employers. The Family and Medical Leave Act, FMLA, has to do with giving employees peace of mind and time off if there's a condition, a major medical condition with someone in their immediate family. So the employer must have 50 or more employees to be required under the FMLA, and that would state that they must give up to 12 weeks of leave time in a 12-month period for either a child, spousal, or parental care, or for the employee's own serious medical condition. So if there is a medical condition, the concept here is to give peace of mind to the employee as far as their working conditions and their ability to continue earning during that troubled time period as they take care of whatever medical condition is necessary. The military coverage leave is a similar law, but is given to specifically military injuries or illness that occurred because of military service. We would have to give employee up to 26 weeks of leave time in a 12-month period to care for family members who had some type of serious injury because of military service. And of course, similar reasoning for the law here to give peace of mind to individuals that are going to take care of close family members that are having some medical conditions, specifically medical conditions related to, in this case, military service. We also have employment laws that deal with discrimination within the workplace and try to reduce the discrimination within the workplace. Some of these have to do with, or some of these would be, parts of the Civil Rights Act, the Equal Pay Act, the Age Discrimination in Employment Act, the Uniform Services Employment and Reemployment Rights Act, the Americans with Disability Act, and the Genetic Information Non-Discrimination Act. The Equal Pay Act has to do with the phrase of equal pay for equal work, and means that an employer must pay women the same amount that they would pay men for the same job, for the same employment, for the same work. The Civil Rights Act of 1964 is an act that would prohibit discrimination on the basis of sex, race, color, national origin, and religion. It covers more than just employment law, but within employment, if an employee feels that they have been discriminated based on sex, creed, color, national origin, or religion, can file complaints with the Equal Employment Opportunity Commission, the EEOC. Workplace harassment can take a few different forms. One of the forms that has been covered in the past most and is covered under the Civil Rights Act under sexual discrimination would be sexual harassment. What constitutes sexual harassment is a bit more unclear. We know that a situation which is a quid quo pro sexual harassment situation would definitely fall under the term of sexual harassment, but some other types of harassment may be more unclear. A quid quo pro situation occurs when a supervisor makes unwelcome sexual advances toward a subordinate or suggests that the subordinate trades sexual favors for preferential treatment of some kind. That's going to be a quid quo pro situation. However, there could be situations where the environment is just a hostile type of work environment, and those types of cases are less clear as to whether something would constitute or be termed as sexual harassment or not. A hostile work environment typically would be a case where there's some type of harassment that makes it more difficult and for an individual to complete their work, or makes the conditions within the workplace a stressful condition that would cause some type of anxiety within the workplace. So it occurs when there's going to be some type of misconduct. It could be sexually explicit comments, pictures, photographs, text messages, Facebook postings, emails, jokes, posters, cartoons, gestures, that pervade the workplace to the extent that it becomes distressing or somehow hostile or offensive to the individual involved, and typically would be a case where it would affect their work and possibly their home and or health. If this is going to be the condition, then the employers are prohibited from restricting or stopping the employee from filing harassment complaints, or restricted from taking retaliatory action against an employee for filing a complaint for harassment. The Age Discrimination in Employment Act, ADEA, prohibits discrimination based on age, and it applies to individuals over 40 years old from discrimination in either hiring, firing, promotion, or other aspects of employment. The Uniformed Services Employment and Reemployment Rights Act, the USERA, has to do with armed forces, people that serve within the military who have completed their service, their duty, and upon returning to work, they should be reinstated to his or her previous position. So that's going to be the idea that there's going to be some type of leave for service, and if that leave took place when they return, they should be employed or put back into their original place before the leave, rather than being put at a lesser place after that point in time. In other words, they shouldn't lose their ranking within the company, their hierarchy within the company, as they do their military service and serve their military needs, or our military needs. The Americans with Disabilities Act has to do with individuals who have some type of disability, whether that be mental or physical, which is going to substantially impair or limit one or more of the major life activities. So these could include things like blindness, paralysis, deafness, cancer, mental retardation, learning disabilities. So these are going to be things that would be covered under the Americans with Disabilities Act. One component of the act is to have reasonable accommodations. So that would mean that the employer is basically responsible to have some type of accommodations that would accommodate people with some disability, if that accommodation is not going to apply some undue hardship to the employer. So, for example, it might be a case where we would want to have the entry to the building to be accessible possibly to someone with a wheelchair. If it's possible to set up the entry level, and in most cases, hopefully that would be possible, then and it doesn't cause undue hardship on the employer to do so, we should be able to set up the facility to be able to do so. That would also include things like access to elevator access, and just ways to move around the office and things like that. We want to make sure that the facilities are designed in such a way that they can make the accessibility there for people with disabilities, if it doesn't cause undue hardship on the employer. For more accounting information and accounting courses, visit our website at accountinginstruction.info.